Mr. Martindale, you can put your hand down. How are you doing, Mr. Martindale? That's good. Mr. Martindale, you're represented in your case by your attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Lawrence, do you waive a record in Mr. Martindale's case?
Oh, yes, Your Honor.
State is represented in this case by Attorney Haley Simmons. Again, Ms. Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking. Mr. Martindale, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Martindale, it alleges that you, Darrell Lynn Martindale, on or about March 31st of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, transportation. Mr. Martindale, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Martindale, how do you plead? Not guilty, guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Martindale, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Mr. Martindale, do you recognize this document?
Yes, sir.
Okay. On page 2 of this same document, Mr. Martindale, there are a set of initials on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
And on page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
The next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Right. Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Martindale, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Lawrence, go over these documents with you?
Yes, sir.
And did you understand everything that Mr. Lawrence went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Martindale, are you a citizen of the United States?
Yes, sir.
State off the state's one.
Do you have any objections to State's Exhibit Number 1, Mr. Lawrence?
No, Your Honor.
No objection. State's Exhibit Number 1 will be admitted. Mr. Lawrence, you have advised and counseled Mr. Martindale. Is there any evidence that he is currently mentally incompetent to stand trial?
None at all, Your Honor.
And Mr. Martindale, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Martindale, I will accept your plea of no contest. I will find that you are mentally competent to stand trial, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. I also find that your plea and waivers were freely and voluntarily given. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred probation, $300 fine, 40 hours community service plus court cost.
Okay. What is the court cost in his case? $352. Okay. Mr. Martindale, the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You'll be required to pay a fine of $300 for score calls of $252. You'll be required to pay probation fee of $60 a month, a year analysis fee, $15 a month, reimbursement fee of $15. You'll also be required to pay in Bergen Jefferson County the court-appointed attorney's fees of $250. Your total monthly installments, that is, the total amount that you will be required to pay each month while you're on probation is $165 a month. Will you be able to pay the $165 each month?
For 12 months.
Each month? Are you able to pay it, or if you, or
For
are
a
you
total
not?
of 12 months?
Yes, it's 165. Well, actually, we divided it by 11 months, but that's how much you'll be required to pay.
For 11 months?
That it comes out to, we only divided by 11, 1 month less. Will you be able to pay the $165 each month? Okay, now, hold on a minute. Does he have a affidavit of injuries on file? Let's see, that's
Oh, that was fire one, so. You probably don't have personally reviewed you, what's it?
Grocery.
okay. Mr. Martindale, I have a document before me that is titled Jefferson County Affidavit of Indigence. I'm handing this document to your attorney, and he's going to hand this document to you. Do you recognize that document?
I do.
And on the back page of that first document, there's a signature above the line at the top left-hand corner. That's above the line that is titled Defendant's Signature. Do you see that?
Right.
Is that your signature?
Yes, sir.
Okay. Now, is everything on that document still true and correct today?
Yes, sir.
Okay, you can give him a pen, he can make some changes.
Oh, it's just my address. Everything else still the same.
Okay, oh, okay,
I'm sorry.
okay, so your finances are still the
Yeah,
same.
that's still the same.
Okay, okay. Let me do this, hold on a minute.
Would you like these forms back, Judge?
Yes. Thank you.
People are in this, they're like, you make it the following week.
Mr. Martindale, the court is gonna find that you are indigent. And based on the finding of indigence, the court costs of $300 and the probation and the fine, no, the fine of $300 and the court cost of $352 comes to a total of $652. That $652 will be converted to 52 hours of community service. Okay?
It'll be 92 hours.
Well, we hadn't got to that point yet, but that's what it's gonna total, but your fine and court costs, you'll be required to perform 52 hours of community service to pay off your fine and court costs,
Right.
okay?
Yes, sir.
And the attorney's fees of $250,
Mhm.
that will be waived, which means you will not have to pay it, and that will be waived pursuant to Articles 26.05 G-11 of the Texas Code of Criminal Procedure. And the $15 reimbursement fee will also be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure, because the court has found that you are indigent. And so therefore, the probation fee of $60 will be reduced to the statutory minimum of $25 a month.
Yes, sir.
And you'll be required to pay the $15 your analysis fee. So your total monthly installments will be $44 a month.
Yes, sir.
Okay, you'll be able to pay that?
Yes, sir.
Okay, and you'll also be required to perform 40 hours of community service in addition to the 52, which comes to a total of 92 hours of community service. Do you understand that?
Yes, sir.
Now, you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Martindale, do you understand the state's offer and the court's findings?
Yes, sir.
And do you think that it's fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, I'll follow the plea bargaining agreement with the court's finding in this case. And Mr. Martindale, if you successfully complete this probationary period, this case will not result in a conviction on your record. And you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Mr. Martindale, this will conclude your case. You're gonna stand at the end, well, just have a seat, and she has to redo the paperwork.
Yes, sir.
And when she redo the paperwork, she's gonna call you back up to her counter. You're gonna follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day.
Thank you.
All right, you're
Thank
welcome.
you.
Okay. Next case is Stephen Johnson. And Mr. Johnson, your attorney, Mr. Jack Lawrence. Mr. Johnson, how are you doing?
Good.
That's good. Now, Mr. Lawrence, I've looked in the file and you have several motions that you have, I got them in my file, that you filed in this case.
Yes, Your
Now,
Honor.
this first motion, I'm looking at motion in limine. That's, we usually address that on the day of the trial.
Sir?
Okay, your motion in limine,
Yes?
we can address that on the day of trial.
Okay, save for the day of trial.
Yeah. Now, your next motion, your motion, is titled. Now, this is, let me do this here. This is cause number 24 CCCR 0760, case of style of state of Texas versus Stephen Johnson. And we have Mr. Johnson, President Court, with his attorney, Attorney Jack Lawrence. Now, your next motion is a motion for notice. And in that motion, you're asking for the prosecution to give you proper notice if they're going to use Rule 104(4)B, motions 10 days prior to the commencement of trial. Your second one is written notice, to give you written notice with full and complete copies of at least 10 days prior to the commencement of trial. In this case, of any records, documents which include the offer pursuant to Rule 803, 804, 902 of Texas Rules of Evidence. Sir, you have to take your hand off the bench. Mr. Lawrence, take your hand off the bench, yeah. And, okay, now let me ask you this here. Normally on these type motions, the attorneys get with the prosecutor, and if they cannot agree on any of these issues, then we come up before the court. Have you gotten with the district attorney's office to see what they disagree with?
No, sir, not on this, no.
And if the state may get just on a reading of this motion, the state has no issue with any of the required disclosures
Okay,
to be made within 10 days. To be made at least 10 days prior to trial.
okay.
So
So as it relates to the notice, motion for notice, the state agrees to that. Okay,
The state wants.
they agree to give you the information that you're asking for.
notice of the stuff that you're requesting at least 10 days prior to trial. We're
They're agreeing to that. They're agreeing to the motion.
They agree, state agrees?
Yeah, so you might, if you want to, just for your records, you might want to put maybe a check mark or something on it.
Yes.
Okay, so let's go to the next one. Oops.
Yes, Your Honor.
Okay, hold on a minute. Let me get to the next one. Oh. Went to the wrong file.
I need to advise everyone, my ears are stopped up, so if y'all can speak a little loud, particularly Andrew over here, if y'all can speak a little louder.
Okay, we'll try to speak a little louder into this microphone. Let me see, hold on a minute. We just did that one. Okay. Okay, let me go to this motion. The motion is titled defendant's motion to separate hearings on inadmissibility of prior convictions used for impeachment.
Yes, Your Honor.
State, have you looked at that motion?
I have reviewed that motion, Your Honor.
Do you have any objections?
No, at this point, like if state intends to use priors in this case as a means to impeach the defendant, which at this point, it does not seem like from what we reviewed in the file that I would be doing so, then I'd be fine with a separate hearing for
Okay, they agree to the defendant's motion for separate hearing on admissibility of prior convictions used for impeachment purposes. The state is agreeing to that motion. Okay,
Yes, Your Honor.
That
That's
being
fine.
said, at this point, the state does not, intend to use it, does not intend to use that priors. But, if that changes during the pendency of this case, the defense will be notified.
okay. So he's saying that they don't intend to use any priors or anything, but if that changes, if they become to light that he may have had something they want to use, they're gonna give you your proper notice,
Yes, Your Honor.
okay? Okay, so the next I did that one already. Okay, here we go. Okay, the next motion is titled Motion to Require the State to Reveal Any Agreement Entered into between the state and any prosecution witness that could conceivably influence their testimony.
And there is no such agreement.
Okay, so the state basically says there is no agreement. Now, if there is an agreement, you would agree,
Absolutely. disclose that.
okay, he would disclose that.
Okay.
Okay, so they're agreeing to that one too. Okay, let's go to the next one. Okay, the next one I have is motion for discovery. And I think the state has an open file policy. Is that correct? In
That's
fact,
correct.
the state has a portal that the attorneys are allowed to have access to all of the discovery in this case. Is that correct?
That's correct. And in regard to media, it has been requested in this case, and those media requests have been fulfilled.
Okay,
I couldn't understand.
Oh, I'll say once more, that is correct that we do have an open file policy and that you have access to all paper discovery. And in addition to that, in regards to media, there have been tape requests in this case that have already been seen and fulfilled by our office. We will continue to give you any and all discoverable information that our office.
So
receives.
I do have all the tapes.
Yes, sir. Yes, Mr. Holmes.
okay. So the state is agreeing to the motion for discovery. Is that correct? State?
I mean, there are certain, when looking at the motion itself, there are certain requests that Mr. Lawrence makes that the evidence would not exist in this case.
Okay, okay.
Which motion is that?
The motion for discovery, production, and inspection of evidence.
Your Honor, that has a number of subparts.
Yeah, I know, but the state,
And many of them don't pertain to this case.
Some of them don't pertain, that's correct.
and so he basically what he's saying is the requests that pertain to the case, they're agreeing to provide you with that material. You should already have it through discovery that you received through the portal, and as well as through the media discovery that you received.
And we can see on our side the defense has been able to successfully review the contents of the portal at this point.
Okay, so what he's saying is that anytime that you have access to the portal, and once you go on in and get that material or even view the material, they are aware, they can tell that you have accessed the portal, and that you are aware of the materials that are in the portal.
Your Honor, I didn't emphasize this heavily, but the complainant, her name is Keisha.
Now, Mr. Lawrence, let me do this here. We are only going to deal with what's in these motions. Okay, is there a specific number in that motion that you are referring to in that motion for discovery? I see you looking at it.
For example, number 42.
Okay, hold on, let me get to number 42. Let us get to number 42. Hold on a minute. It says, all medical and psychiatric records submitted by any doctor, psychiatrist, psychologist at the request of the state or the court in conjunction with any examination of the defendant or respondent, the complainant,
Plaintiff.
and all state witnesses. Now, you saying that the state have that type of material?
From what I understand, and I could call a witness on it if I.
Well, this is
But,
not an evidentiary hearing.
From what I understand, the complainant has something of a mental health history.
Okay, well,
What was that?
that's not in the state's file, I don't think, because the state has provided you with
We
all that
haven't
they have,
received-
Right. And
We
there's-
haven't received any information on that, although
because they don't have it.
I have made the state knowledgeable of some of the hospitals she's been to here.
Okay, but they don't
Yeah, and
have it.
looking at number 42 in your motion, it requires that we hand over all this information that has been obtained at the request of the state. At this point, that has not occurred. There's been no such medical or psychiatric reports made at request of the state to give you.
And if I'm not mistaken, if
Then
that information is out there, you can request that information as well.
I can do that, but they should be able to obtain that. Since she does have a little history, they should be able to obtain that.
But you can't tell the state how to try their case. Okay, if you need the information, you can
There's
get
a
it yourself.
problem about most of this is subject to rules of non-disclosure. There are statutes that say this type of psychiatric history isn't necessary. Doctors are forbidden to disclose it. Now we are in a case.
You can subpoena the doctor.
Huh?
What stops you from subpoenaing her doctor?
I can do that once I find out who the doctor is.
Okay, well, that's not the state's, the state has a file. The state has the evidence that they're going to use to prosecute this case. You have a defense, okay? And you can't expect the state to, you can't tell the state what evidence to go get.
They can find out if,
They don't have that information in the file, is that correct?
That's correct.
but they can find out and I can't. Yeah, I'm forbidden by statute, I believe.
Or you
They can
say,
find
hold on,
out.
the operative word is, I believe. That's the operative word. You say you forbidden by statutes, you believe. There's
Well, what I
something
know
that's called subpoena, that you have a subpoena power. Just like state, you can subpoena records. But the state, the state doesn't have that in their file. If they had it in their file, you have the right to have access to it. You can't expect to come up with ideas and theories and tell the state that you must go get this. It doesn't work like that. So you still have the subpoena power, just like the state has subpoena power. If you think it's more favorable for your defense, that would be something that you would do. If they had it in their files, obviously, you're entitled to it through Brady. But they don't have it in their files.
They can obtain it and I can't.
Have you tried to obtain it?
No. I
Well,
don't-
how do you know you can't obtain it?
I don't know exactly where to look. I know of
Okay.
one hospital that this lady here has told me about where she visited. I'm not gonna go
But
into-
at this point, as far as that request is made, the state, that's 42. Submitted by any doctor, psychiatrist at the request of the state. At the request of the state, hadn't made no request for any, I'm just reading your motion. You said all medical psychiatric reports submitted by any doctor, psychiatrist, or psychologist at the request of the state. The state have not made a request for none of that material. So if they do make the request, you'll be entitled to it. So we can grant the motion, but we can't order the state to make a request.
I will make a direct request from the state to give her psychiatric records at hospitals. And I'll
Not
name
under any
particular,
Yeah, they're not, I mean, not, Mr. Lawrence, again, you have the right, you have a subpoena power. You can subpoena records of,
I'll try that too,
Patients.
Your Honor.
okay. All right, next. Is that all on that issue, on the discovery? So everything else, basically what state has?
I mean, in regards to anything that applies to this case, Your Honor, we are going to provide any and all discoverable information that we have to Mr. Lawrence.
Okay,
We also, I think we would like a response to items 48 through 50.
hold on, well, let me do, let's get to 48. 48, any evidence in the possession of the state or its agent, okay, or within their knowledge that the defendant or respondent has ever been adjudicated or declared insane or incompetent. So any information that's in the state's possession or its agent's possession. Do you have any?
No such information at this time, Your Honor. If we do receive that information, it will of course be given to defendants.
Okay. All right, next, 49, the criminal record of each witness for the state showing every conviction or probation for felony or misdemeanor involving moral turpitude, which is admissible for impeachment under Rule 609 of the Texas Rules of Criminal Evidence.
In regards to that one, Your Honor, we, as far as like NCIC, TCIC, we cannot give physical possession or custody to Mr. Lawrence in that case. If he has specific questions regarding that, we can give him answers to those questions, but we can't hand over possession or.
And he can
or
ask whether or not the witness has ever been convicted of a felony or misdemeanor or involving moral turpitude, or whether or not, okay.
That's what we're requesting.
So you don't have any you don't have that in your in the files. Is that what you're saying?
She supposedly has a little record, but I don't know much about it.
Okay, so we have that in the case file, but it's not discoverable information. So
Oh,
we
okay.
can't, so we can't give him like possession or access to it, but if he has specific questions regarding either the defendant's criminal history or the criminal history of a state's witness, which I guess we'll get to that issue whenever we take up the motion involving a list of state's witness, but
Okay,
if he has specific requests, then I can answer questions regarding that, but I can't give him access or possession.
okay. Did you understand what he said?
I think so.
All right. 50. The criminal record of each witness, is that kind of the same?
That is in regards to state's witnesses, Your Honor, which as with the previous
State witnesses showing that's for impeachment purposes.
which as with the previous number, Your Honor, we can give him answers to his specific questions regarding that, but we can't give actual possession of that information.
Okay. And that's 51. All information regarding defendant which was obtained by the police, in this case through the Crime Stoppers program.
There's nothing to the state's knowledge that anything was reported to be a Crime Stoppers in this case, so there's no such information to disclose.
Okay. All recorded incoming telephone calls to 911 or the sheriff's office or the police station requesting assistance at the time this incident was reported.
calls to emergency services would be in our media, Your Honor.
Or he should already have that in the media if y'all had it?
Yes, Your Honor.
Your Honor, it wasn't, the alleged victim, Keisha, that called the police. It was, the landlord, which is, sitting right here, Linda.
But
But we're getting into that.
irregardless of who called, if it was a 911 call, it's in the media that you received. Have you listened to the media?
Oh, yes, it was Linda Pittman who called the police.
So you do have the 911 call.
I need to see if, yes, I'm not positive, but I think I do have a record of Linda Pittman's call.
Okay.
But I need to have the call by the alleged victim if there was one. I'm not at all sure there was one.
Well, if there was one, I'm sure the state would have it. Do
Right.
y'all have a?
And that would be included. And there's also a
I don't know
Listen,
that I have that.
there's also a document in Discovery. Let's see. Sorry, but there should be a document in Discovery, and I'm going to confirm that that is the case right now, called a call sheet, which will have information on calls to emergency services in the case.
He said there's a call sheet that should have that information from emergency services as to probably the time they called and who called.
And
that was part of the discovery that you gave to Mr.
that's what I'm
Lawrence.
confirming right now, Your Honor.
Okay, hold on a minute.
I may have a call sheet.
And in addition to that, okay, there is a call sheet and event report in Discovery. And in addition to that, any calls to emergency services would be put in the media to begin with.
Okay, so if any calls that was made, it will be put in the media. You can check your media, just kind of double check it to see if.
And if you have,
Go ahead.
I'm sorry, Your Honor. If you have any reason to believe, after reviewing the file that there should be another call, then just let me know and I'll look into it.
Okay,
There's also the call sheet is in addition to that, isn't it? The call sheet doesn't look like this. It's in addition to this, isn't it? I believe it is. I can't find it right now, but. Oh,
This looks like that report. But again, I will say if there is any reason to believe that an additional call to emergency services was made, I will look into it and
my present understanding is that the only person who called the police was Linda Pittman. If you find another call if you find one by Keisha Monique Williams, I would appreciate your informing me.
okay. Let's see. And I guess that'll also go along with 53. What 53 and 52 was basically it's like all recorded communications between the dispatcher and our law enforcement agents who were called to the scene in this case.
And a lot of that would also
All that would be on recorded media if they had video cams.
Yeah, that's what I was about to say, body cam.
Body cams, yeah, that would be on body cams. If they had it, you'll have access to that too.
Yes, Your Honor.
Okay, and then all victims' impact statements which contain materials
Which I don't see a victim impact statement.
Okay,
there's a statement from the victim, but not a victim impact statement.
Okay, or mitigate disposition as required, okay. Okay. So that concludes, that motion.
Yes, Your Honor.
That was the motion for discovery. Let's see, what about the witness list? There's a motion. Yeah, is that the same motion? Motion
The motion was.
to list witnesses?
Yes,
Y'all,
and there's also something else in that motion,
okay, it moves to the director.
which I think we've already covered, the issue involving criminal history and what the state can do in regards to that.
Okay,
Which
I
is,
would be interested in any mental health history of of Keisha.
I recognize that you're interested in it, but I don't have the duty to seek out and give you that information.
you can find it yourself. You can get it yourself through the power of subpoenas. Okay,
I'm not
so,
sure about that, Your Honor.
okay, well, I practiced law too before I was a judge. And I subpoenaed a lot of records that the DA didn't have. Okay. So regarding this motion, Mr. Hubel, the witness list,
I would provide Mr. Lawrence with a list of all potential witnesses for the state prior to the trial setting. Your Honor.
okay,
I
okay,
have no issue with providing him that list. The motion also covers
the criminal histories,
yeah,
right?
which I've explained that we can answer any questions regarding that, but we
Right.
can't give actual
I believe that's required like 15 days before a trial.
Apparently, he's gonna give it to you a lot sooner than that.
That'd be good.
Yeah. Let me look at this. I think the next motion is the same motion twice. Yes, the same motion. Okay. Let me go to the next one. Motion to present. Let's see what that is. Hold on, I'm just talking to myself. Motion, the defendant's motion to preserve investigatory and clerical notes and materials as evidence.
In regards to that motion, state has nothing to hide in this case, but will be maintaining its privilege to work product for material generated during preparation for this case. But other than that, any recordings or records that we produce that would be discoverable by the defense, we will happily turn over.
And I would include the Beaumont Police Department. You know, I don't think that I was as,
Yeah, you said the Jefferson County Sheriff's Department or the Department of Public Safety.
and that would also, I meant to include the Beaumont Police Department through Your Honor.
Okay, mitigating civil risk, but not also possible impeachment. Yeah, so if they had any, okay. So State, what's your response to this motion?
As stated earlier, before, with the exception of material that it's privileged work product, the state has nothing to hide in this case and will turn over anything and everything.
Okay.
Recordings, records generated during this case. They're discoverable to defense.
Okay. Did you hear that, Mr. Lawrence?
Yes.
Okay. So let's go to your next motion. Let's see, motion to arraign. You're not gonna arraign him again. Yeah, you said motion to arraign accused outside the presence of the jury. He's already been arraigned. So that's mute. And we go to the next motion. Moot, not mute, moot. Let's see, motion for separate trials. Did we talk about that? Well, motion for separate. Okay, inside of the court instructed jury mentioned allude to refer to a manner of prior convictions hearing. I think we already
covered
did,
this one.
we did a motion for separate, yeah. That's apparently you filed the same motion twice. There's two motions in there, like it was filed twice in the same court.
I think I did. do that.
The only,
On
the
one.
only difference it seems is there's like a single wording that's different, separate hearings versus separate trials.
Okay. Okay. And let me see this one, I think, the motion for combination trial. Motion, and this is basically you asking for a court reporter to record the proceedings, and you will have a court reporter recording the proceedings.
State would of course agree with that. We would also
Yeah.
make a record.
And now you electing for the judge to assess punishment, right?
Yes, Your Honor.
So that's,
We actually do not want a jury. The state may want a jury for the trial portion if that's their option, but all we want is a judge for the whole thing.
So you want to.
you didn't say that, you said two different things. So are you waiving a trial by jury? That's what you're saying?
Yes, we are.
Okay, well, yeah, there's a form up there that you would have to sign. And the state would have to agree. There's a form.
Yes, we'll do that.
Okay, so we'll come back to that.
Okay.
Okay. So I mean, if the jury is waived and if he's found guilty, the judge says punishment anyway. So it's not,
Fine.
okay. Okay. Motion and notice of hearing. Hold on, let me see what this says. I think this
So,
is what's that?
Going back to the combination of trial motion, just to make sure, I believe that there was a third section in that motion.
Oh, okay, let me get back to it. Okay, so we got the court reporter. We have in the next section, election of punishment, arraignment outside the presence of the jury. He's already been arraigned.
Right. And I just wanted to make sure that that was
Yeah, we already talked about that. He was already arraigned. That's
right.
That's
And
moved. Yeah, that's moved. Okay. Okay, so let me see, this last motion says notice, oh, that's it. Because this notice of hearing just was a notice, sending them notice of this hearing. Okay? So that's all of your motions. Okay? And
Did you find the motion to compel disclosure?
There is, okay.
oh, hold on, motion to compel? There's a motion to compel. Hold on, I missed that one.
Which,
Okay, oh, that's Brady material, right?
That's, all of this is pretty much Brady, almost all of it's Brady.
which the state's response would be similar to that, its response to the motion for discovery in general, that will disclose any and all information that is discoverable to the defendant.
Okay,
That's good.
okay. Now,
And there's also a motion for a separate hearing on the admissibility of any prior convictions.
And
Did we do that?
already agreed to that.
we did,
Huh?
I think we did
already
that.
agreed on that.
We already agreed to that.
We were, okay.
Now you stated that if you are planning on waiving a trial by jury, there's a form, is there a form over there?
We
It's
need
a
to do
waiver of
that.
trial by jury.
We need to do that.
Oh, I don't know if it's out, I know it's in that stack, it could, I don't know if it's in, is it in the middle? Okay,
So to be clear, you want to waive in regards to both guilt.
From the way the appointment notice read, and from what I could tell from the information, is this a family violence case or not a family violence?
Oh, let me look at the information. I mean,
Down to-
it's labeled. Hold on, let me see.
I'll pull up the-
I'm gonna pull it up too. Family member by punching in the head further at the time the last brother was a member of the defendant's family. Yeah. That's a family violence, yeah.
It is?
Yeah.
And what statute would that be?
Well, it's assault family violence.
All right, it's
And
not
it-
family violence.
Yeah,
Yeah, and it has some interaction with the family code.
yeah. It's a class A misdemeanor.
I believe a niece.
Okay, well,
Does
we
that matter?
we don't need to get into the facts of the case or anything.
But that's sufficient to be.
I mean, just, there's a statute that defines who is a family member
Okay,
in the family code. It's also in that section.
it's in the
Family-
family code?
It's base come out, but it's in the section of the, hold on a minute. Oh, man. Thank you.
I just wanted to make sure.
Okay, court is back in session. And cause number 24 CCCR 0760, case of style of state of Texas versus Stephen Johnson. Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Mr. Johnson, I have before me a document that is titled Waiver of Jury Trial. Do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
Yes, it is.
And Mr. Lawrence, you have joined in on this waiver, is that correct?
Yes,
And state, Mr. Huber, you've also joined in?
That's correct, Your Honor.
Okay. And so, now, before you sign this document, did your attorney go over this document with you?
yes.
And did you understand everything in this document?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes, it is.
All right. So the court will be recessed. The case is going to be reset for non-jury trial or bench trial on November 1st of 2024. Mr. Lawrence, you'll get your reset. Mr. Johnson, you get your reset from Mr. Lawrence. Once you get your reset, Mr. Lawrence, you'll be free to go. And Mr. Johnson, once you get your reset, you'll be free to go. And state, you're free to go. And this will conclude the calling of the day's pretrial conference docket on today of September 27, 2024 in County Court at Law number 2. Everyone, please have a blessed weekend.
Thank you, Judge.
Thank
You're
you, Judge.
welcome.
Andrew.